This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Okay, so you need to have a little bit of background to fully appreciate this next story, but it's a doozy. For the past 8 years, there's been more than one, but there's been one particular copyright troll that sort of outclassed them all. A company called Malibu Media was formed by Colette Pelletier and Brigham Field, her husband. He was a photographer, she was a real estate agent of some kind, and they decided to get into an entertainment industry for adults. There we go. That should pass YouTube's muster. Their videos and content were some of the most popular of that kind of content, basically in the world. And it became popular with pirates. Malibu Media began filing mass lawsuits. What do I mean by mass lawsuits? I mean that over the last 8 years, they filed some 8,000 lawsuits. The major thing to take away from this is that BitTorrent shares as it downloads. So that means that your IP address, whatever IP address you're using, is exposed to the BitTorrent swarm, and therefore any peer that connects to you knows your IP address, and they can just log that. A good example of this, a positive example of this, is HBO, who uses this kind of technology to monitor BitTorrent activity to see which shows are popular. And we get headlines like Game of Thrones was one of the most popular, if not the most popular, pirated content of all time. So this is a story about the fall of Malibu Media. Now, Malibu Media got sued by one of their old law firms called the Lomnitzer Law Firm. About August of last year, they had a falling out with Lomnitzer. It appears the bills aren't being paid. And so Lomnitzer filed a lawsuit. Now, you don't normally file a lawsuit against your clients, so you know you have to be really serious about, a lawyer has to be really serious about wanting to pursue something. Malibu Media apparently never responded to that lawsuit. I don't know what's going on with Colette Pelletier, or Pelletier. I don't know if maybe it's French. I don't know what's going on there. They had we looked at this in a previous video. They had a property in California that was sold under some weird circumstances that I didn't understand. And now there is a motion for a default judgment for them having not responded to the lawsuit against them. And so I thought we would all enjoy a little bit of a read through of this downfall of a copyright troll. And it goes, now comes plaintiff by and through undersigned counsel and moves for default final judgment against the defendant, Malibu Media, pursuant to this court's order, and states as follows. So the court had previously granted a default judgment. You'll see that here in a moment. Defendant was served with a summons and complaint January 12th, 2020. Defendant's response to the complaint was due February 7th. No response has been filed, and no application for an extension for time has been filed. And that's how to lose a lawsuit real quick. If you don't respond and you've been properly served, there's not a whole lot that anybody's going to be able to do to help you. The clerk entered default on February 10th. So the clerk noted that nobody had responded, and the clerk entered default automatically. The concurrently filed affidavit declaration of Lori Lomnitzer, president of Plaintiff, the Lomnitzer Law Firm, established the following. The Lomnitzer Law Firm provided legal services to defendant pursuant to an engagement agreement, including but not limited to coordinating litigation on behalf of defendants on a nationwide basis, receiving settlements of such litigation, depositing such settlements into the firm's trust account, that's going to come into this, and paying certain fees and expenses in connection with Malibu's litigation. So usually the way I would expect this to be conducted, and I don't have any knowledge of the attorney-client relationship beyond that wall of confidentiality. But my assumption as to how they conduct this litigation is that there's a kind of pool of money in the trust account from settlements that are coming in, and they're paying for new lawsuits from that pool. And then maybe the settlements that are coming in aren't enough to cover the expenses of the litigation, and something went wrong along the way. That's my assumption. The firm issued invoices to Malibu on a regular basis for services provided to Malibu under the engagement agreement, paid some of the firm's invoices from monies deposited, and remitted monies from the firm's trust account to Malibu. So they actually did pay something to Malibu. On or about October 31st, 2018, the firm and Malibu entered into an addendum to the agreement reflecting, among other things, the frequency of invoices to Malibu, the maximum amount of services to be invoiced each month, and the frequency of payments. So there were some limits put in place, it looks like, by the client. The firm issued invoices to Malibu on a regular basis for the incurred expenses in connection with the provision of those legal services. Beginning at a date presently unknown, Malibu began a program of circumventing the agreement, the addendum, and the relationship between the firm and Malibu by instructing attorneys in various jurisdictions that were representing Malibu in the nationwide litigation to bypass the firm and remit settlement monies from such litigation other than to the firm. So yeah, they admit it right here. The attorneys were asked to bypass the agreed upon payment method, so the monies went straight to Malibu instead. And they still expected the firm to pay the expenses incurred for the benefit of Malibu. So there's nothing shady going on there at all, right? Absolutely nothing shady going on there. The facts in the complaint are verified as the defendant's new or last known address, and the various dollar figures have been corrected or updated. The current status is as follows. Plaintiff is currently holding $58,284.34 in its attorney trust account. Defendant currently owes plaintiff, so that means Malibu currently owns the law firm, excluding interest, $262,549.92. Defendant further owes plaintiff $17,508, I guess for interest. Yeah, it looks like interest. Defendant further owes plaintiff a different amount of interest for a different period of $7,876. There are various third-party invoices of $10,888. And this action has costs of $475, which I'm guessing is $400 for the litigation for the complaint, and $75 for service, and reasonable attorney's fees based on the attorney fee provision in the engagement agreement, whatever that means. So the total amount defendant owes plaintiff is $299,298.16. And based on the number of lawsuits that I'm seeing from Malibu Media, there isn't any of that. There isn't enough litigation going on right now. If you remember, they just lost a case in Texas. I'm challenging them in DC, and I couldn't really even tell you where the heck else they've got lawsuits out right now. In DC, get this. In a DC case that I specifically went to DC, I don't know if you remember this, back in December, I went to DC to get admitted to the DC District Court, specifically for a Malibu Media case. And in that case, we filed our answer and we filed a counterclaim against Malibu, and they turned around and tried to dismiss the case, and I'm currently fighting them on that dismissal of the case. If the court lets them dismiss the case, I anticipate that they won't refile their case and will just run away, which is good for my client, but then my client doesn't necessarily get to recover their fees and costs. So we're fighting them on the dismissal. Plaintiff provides copies of the engagement agreement and invoices to the court under seal. So that's important. We don't want to breach client confidentiality, even when we're suing our client, because they've breached the engagement agreement. And they request relief as the entry of a final default judgment in the amount of about $300,000. And they ask for authorization to take the money that they already have in their trust account. Without authorization, attorneys are not allowed to touch money in a client trust account. That money is sacred. It belongs to the client. And until the court allows the attorney to transfer the funds from the trust account, that money can't be touched. So, and unless they have client permission, which it doesn't appear they have client permission yet. So they are going to apply those funds to the invoice's oldest first.
So I have a question.
I have an answer.
Maybe. We'll see. I remember from the dispute between Michael Avenatti and Stormy Daniels that he had tried to place a lien on one of her cases, saying that if she received money from that case, that it should go to him first.
Yeah.
Is this something that the Lomnitzer law firm could do to Malibu Media?
Yes and no. An attorney's fees lien is a real thing, I believe. I haven't really used them too often, so I don't want to speak out of turn as if I do. But it is a real thing, kind of like a mechanic's lien. Like if you take your car to the mechanic and then you don't pay the mechanic, they can put a lien on your car in some states. And what's a lien? A lien would be like a mortgage on a house, but it would be on something else, like the car in a mechanic's lien situation, or on the proceeds of litigation in an attorney's fees lien situation. Or a tax lien. If you don't pay your taxes, the IRS can put a lien on your house or a lien on your car, and then you can't sell your car or your house without first paying off your taxes. So yeah, that's a thing that can happen. I don't know that Lomnitzer, so I believe Lomnitzer got more or less fired from all litigation. And so I don't think Lomnitzer has any awards coming in from litigation to put liens on. So that may be why we don't see that here. And then there's something that's weird here. You'd think this relief requested would be the end of it, but it's not. There is something weird here that I haven't seen before. A special certificate of service. In federal court, whenever you file something with the court, you also have to acknowledge or notify the court, on the public docket, as to how the opposing side was served. Now, we get a little bit lax with this in federal court because the case management electronic case filing system, CMECF, does all of that for you. So sometimes it's easy to forget that you're supposed to at least put a line or something that says, here's how the person was served. Recently, I've done some letter motions, and just like at the bottom, I put CC, which means carbon copy, all parties via the CMECF system, so that at least everyone knows how people were served. When you're not doing a letter motion, you would do something like this called just a certificate of service, and it would say something like, on such and such a date, I perfected service on all all interested parties through the electronic notification system of the CMECF. This one is a special one, though. What is special about it? This is the real fun part, guys. Heads up. On February 10th, 2020, the undersigned, who would be the undersigned attorney, so Lori Lomnitzer, the undersigned received an email from attorney Jason J. Kotzker stating, Miss Pellessier has asked me to reach out to you to request a short extension of time within which to answer the complaint filed against Malibu Media. This firm, which means Kotzker's firm, this firm will not be handling the matter, but is seeking a professional courtesy of an extension on behalf of the company. I believe a week or two would be sufficient. The email was sent from that email address. Miss Pellessier, which is Miss Colette Pellessier, has been identified as the principal of Malibu, that's the principal owner, and the person who signed the engagement agreement with plaintiff on behalf of defendant. Also on February 10th, the undersigned counsel received an email from a different attorney, David E. Rosen, stating, "This follows up my earlier voicemail. I am counsel for Malibu Media. We are in the process of locating counsel to defend the above-referenced action. Please let me know if you will agree to a 2-week extension of time to respond to the complaint." The email was sent from that email address. The undersigned responded to both of the above emails on the same day, but has not heard back from either attorney. What? So you're facing a default judgment, you ask for an extension of time, and then you just don't respond? I hereby certify that copies of the foregoing motion and affidavit declaration of Lori Lomnitzer have been served as follows on those email addresses. The court's order requires a copy of the motion to be sent to defendant, and because the aforementioned attorneys have not confirmed they represent defendant in this matter, a copy of the foregoing motion and affidavit declaration of Lamitzer have been served on defendant by first-class mail, postage prepaid, to this address in Westlake Village, California.
Because normally, if someone is represented, then attorneys are obligated to speak to other attorneys. You don't speak directly to someone if they're represented.
Right. So, also if the attorneys are saying that their firm is not handling the matter, but they're representing Malibu in some way, it's difficult to know whether they're the proper party to serve or not. And how much information to share with them. So yeah, that's a really weird situation for Malibu to be in. Why in the world wouldn't they respond? Maybe like, I was recently out of the country. Maybe they're out of the country and didn't get the first class mail postage prepaid. But that's weird because there's two attorneys here that say that they represent. And so, yeah, I think that they've perfected service or effected service through this method. And the only thing that I could see the court doing is maybe the court will want to make sure that there wasn't some service of process issue. But there shouldn't be. There shouldn't be a service of process issue because, as it says up here in the beginning, they were served on January 12th. Defendant was served on January 12th. So if that means, so what does service mean? Service of process is a critical component of the beginning of any lawsuit. You can file a complaint and nothing happens. You actually might even get your complaint dismissed after 90 or 120 days. I think it's 90 now. If you don't either ask for an extension of time to serve or serve within the 90 days. And how Malibu would be properly served, which means personal service. It means someone comes to your door and hands you a copy of the lawsuit and says, "Are you Colette Pellessier? Here's your court documents," and maybe even has them sign something, but that's not necessary. The process server is the witness of the service. Now, there's other ways to serve. Malibu Media is an LLC, so they might have a registered office address, and so service of process happens at the registered office address. Maybe somehow Colette Pellessier missed something here, but it doesn't sound like it if then there's this special certificate of service at the bottom that says that Attorney Kotzker reached out on February 10th. Now, February 10th was also the default date, not the February 7th. So it sounds like someone really dropped the ball here. And I'm really wondering, I mean, the worst that happens to Malibu at this point is they owe $300,000 plus any attorney's fees associated with this action. And I don't know if they've got that or not, but they did own a rather nice Malibu beach house that was recently sold, I think. So maybe they've got the money for it and they just sort of dropped the ball on this one. I really don't know. But what you're watching in real time here is the downfall of one of the largest copyright trolls in the history of copyright trolls. And I'm really happy about it. I don't know if you can tell. This was my job for 8 years, was fighting Malibu Media. And so I'm going to be able to move on now, I think. And I think I'm going to be moving on to more of lawful masses and legal education and trying to take this to the next level. If you guys know Legal Eagle, his content is just tops. It's just like really top-notch stuff. It's well written. He's in a snazzy suit. I know I don't do the suit thing. I do the anti-lawyer thing. We have a different kind of show than Legal Eagle, but I'm a little envious of his 868,000 subscribers. He's obviously doing a great job. I aspire to that same kind of thing. So I'm looking forward to being able to focus more on content creation and legal education and reaching you, my audience.
To give people an idea, like they could file thousands of lawsuits in a year, like more than 1,000 at their tops, right?
Yeah, they had filed probably more than 1,000 lawsuits at their peak. So that's what's happening there. We'll keep apprised of anything else that happens, and maybe there'll be a small follow-up video or something. And remember, the worst of the worst copyright trolls really handled it poorly, and they're in jail now. John Steele and Paul Hansmeier from Prendel Law are currently serving time. I believe John Steele is here in Pennsylvania in Lewis. No, I forget where it is. It's Lewistown or something. There's a prison in central Pennsylvania that I think is housing John Steele right now. It's federal because it's a federal crime. And yes, and Paul Duffy passed away. He was, I believe they used him. I'm not saying that he didn't have, he didn't have a role. I'm saying that he was an alcoholic, and I don't think they helped him overcome his alcoholism so much as they took advantage of his alcoholism. So Paul Hansmeier got something like 15 years or something, and John Steele got something like 5. John Steele cooperated. Paul Hansmeier did not. And so Paul got a longer sentence. I think it was like 12 or 15 years for Paul, and about 4 or 5 for John Steele. So anyway, that's the end of Malibu Media, at least I think. We'll certainly follow up on the death rattle that's inevitably going to happen, and maybe put together a comprehensive scripted story. Maybe we'll write a scripted story about the entire thing from beginning to end, everything we know about Malibu Media, or at least all the juicy stuff, and make a video about that. All right, everybody, thank you for joining me. That is our show. I really appreciate your support and the community that we've created here, and this is a beautiful thing we've got going with Lawful Masses. Please consider helping us continue our mission of fun and educational legal stories and news for you on a daily basis, brought to you by me, Leonard French, your Lawful Masses host. Please consider supporting us on sponsors.com/law or patreon.com/ljfrench. These people have supported us in the month of February at the $50 or more level. Aspernari, Video Demonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Stephen, Cute Grills in Your Area, Ottah, Keisel, and Longreach Jones. I really appreciate all your support, and there will be $5 plus supporters scrolling on the screen in front of me. I'll see if I can put some dog video on the outro here, as we've got dogs now that I'm back in the States, and I look forward to seeing all of you in the videos that drop. Remember to subscribe on YouTube, click the bell to get all your notifications of our daily videos, and I will see you there. Love you all. I'm Leonard French, your favorite copyright attorney. Have a good one. Bye. Oh, yeah? Did it drop? Nope. Oh, you do drop the ball now. Okay.